Okay. Welcome everybody to the tax section program on Sharia law, or I should say Islamic law and financing and U.S. tax law. I'm Michelle Weiss and I'm the chair of the tax section. But before we begin, we have a couple of housekeeping announcements. You'll receive your MCLE certificate shortly after the program. Your certificate will also be stored in BHBA Plus, our members only community. Please take a moment to complete the survey that is included with your certificate. This program will be available in a couple of days in BHBA On Demand, BHBA's newest member benefit presented by Lawyers Mutual Insurance Company. We also want to thank our tax section sponsor, Hochman, Salkin, Tasha, and Perez PC. The Hochman, Salkin, Tasha, Perez PC advantage is experience, an eye for innovation, and a genuine dedication to clients, their families, and their business. In addition to their national practice in civil tax and criminal tax controversies and related litigation in federal and state courts, the firm is also active and successful in handling non-tax matters such as business and estate planning for high net worth individuals and closely held businesses, together with white-collar defense and commercial disputes. And with that, I want to introduce our speaker in our program. Our speaker, Jared Johnson, will discuss how to help clients harmonize conflicts between the federal tax obligations and their religious practices. Jared Johnson is a partner at White & Williams LLP. Drawing on his influence in French, Portuguese, and Spanish, Jared advises clients on matters related to cross-border transactions, helping numerous family businesses and high net worth individuals minimize their risks and tax liabilities through strategic business administration, estate planning, and legacy planning. Jared holds a certificate in dispute resolution from the Straus Institute for Dispute Resolution at Pepperdine University School of Law and is skilled at finding leverage in a dispute to force settlement. However, having practiced extensively before the IRS and the Department of Labor in examinations and in tax court litigation, he is prepared to fervently advocate for his clients in any setting. He is also a CPA. And with that, Jared, I will let you take us away to discuss today's program.
Thank you, Michelle. I do appreciate that. I think you put that very well when you said harmonizing the conflict between the religious observance of Sharia law and the U.S. tax code, because some specific rights that we have under U.S. law certainly create issues, and we're going to see a little bit down the road how what might appear as a conflict actually can be harmonized. So I love that you brought that up. A lot of what I do during the course of my practice, because I have a number of cross-border issues that come across my desk over the last few years, I've found an influx of Sharia compliant transactions. The Muslim capital community is growing. And in fact, and a lot of that is what has led to my gathering a lot of the information that I'll be sharing today. And there's nothing particularly new or groundbreaking, not necessarily strategies or structures that will minimize tax, but more today is more of a survey and an understanding of what the issues are, what some of the tools are, and some of the things that we face as we encounter more and more of these Sharia-based transactions. And that raises the question, so why bring it up? Why talk about Sharia law when you consider that Sharia law is not law in the statutory sense, at least with respect to as U.S. citizens understand law. It's what the government has passed and it's what we abide by, but rather because of the prevalence of the religious observance of the Muslim community and the rules that they have to live by, it is law, and we want to make sure that we help them with compliance and make sure that they are getting the full benefit, not only of the observance, but also of the protection of the U.S. tax code. So we see that, and also with more and more cross-border transactions, my most recent count, we are at about 24 countries around the world that have actually codified Sharia law. So when we're talking about cross-border transactions with those particular countries, now there are a couple that have parallel tracks where there's ordinary civil law and Sharia law, and you get to choose. That's why it's 22 to 24. But when we're dealing with those cross-border transactions, we need to make sure, as Michelle pointed out, that we harmonize that foreign law with the U.S. tax code. So we see that growing more and more. We'll talk about a few points throughout the course of today. Let's go to the next slide. We'll talk about U.S. folks and the application of the law to that, the foundations of Sharia law. There are individual level considerations. There are just a couple juicy points that I wanted to identify there. And then we get into loans and structures, home and retail finance, which is very common. This is where on the tax side, we run into a lot of the issues with interest being one of the more commonly recognized Sharia rules, is that you can't charge interest on a loan. So obviously, when mortgage is notorious for having loan interest. So we'll talk about that a little bit. Let's go to the next slide. We have insurance contracts. Again, there are interest issues there. Real estate investment, that's where we get into the private equity and investment funds, the same thing. Capital financing combinations, again, through all of these, we have banks being involved on the retail finance, the real estate investment funds. All of these things involve banks, and naturally banks thrive off of interest. So the question then is then raised, okay, so how do these Islamic banks treat Sharia compliant financing here? And then how does that translate to our clients who are US persons and how they report it on their tax return? So and then finally the waqf, which is short answer, it's similar to a trust, but there are some key differences that we may want to be aware of. It's more of a religious-based trust, and we'll talk about that at the very end. So let's go to the next slide, please. All right. So of course, a U.S. person as tax practitioners, that's a pretty 101 question. Are they a U.S. citizen? Are they resident alien? The question that we want to be aware of are folks who become accidental Americans. And that can happen around the world. Now, one of the aspects of Sharia practice that has become more prevalent and we've seen is the common use of what are called hawalas. And those are Sharia compliant money transfer systems. Those and hawalas have been around since about the 8th century, beginning in India, and they are informal money transfer systems that families use to transfer money from family to family to family within the current modern tax system or banking system. So that's existed for hundreds of years, and it's still prevalent today. And you have certain individuals who may be involved in this money transfer system who are deriving income from the money transfer process, who are accidental Americans. they may have derived some US source income that they are not aware of. So it's important to know that. Now, I do want to point out, though, as you work with hawalas or you see them, you under Sharia law, you cannot charge for the money transfer process. It has to be $1 for $1. And so there are perhaps some gaps in the exchange rate where families can utilize those gaps to collect a penny or two off of a money transfer without it being a charge on that dollar for dollar or whatever the exchange ratio is, so that they can derive some profit from that process. So that is just something to be aware of, and we're going to go into some more specifics on that in just a moment. Actually, let's go to the next slide. We'll talk about that now. All right, so the general concept of Sharia law. First, we'll talk about where it came from, and then we'll talk about some principles. So we've got the base document, the core document is the Quran. Very, very commonly known. Most folks are aware of the Quran. That is the holy book. And that's where the foundation for all of these laws come from. And then building on that, we have what's called the Sunnah. And these are words or practices that were instituted or approved by Muhammad. And in the Sunnah, that includes the Hadith, which are oral traditions. They're interpretations of the Quran. And those are passed down. And they are, a lot of those were gathered and they were compiled by what's called the Sabah. And those were the close friends, the close circle around Muhammad. And then on top of that, you have the Ijma. Ijma are derivations. They are reasonings from Muslim scholars that take the Quran, they take the Sunnah, and they apply it. They derive judgments or determinations from those two. And these Muslim scholars, they have to be qualified. There are certain rules that they have to follow in order to be able to officially interpret Sharia law. And then on top of that, you have what are called qiyas. And qiyas are interpretations of all of those other previous foundations. They're interpretations based on analogy. And that analogical reasoning allows for a determination for a particular situation or set of circumstances. And if you look at the Ijma and the Qiyas, those two combined comprise what's called the fiqh, which is an understanding and knowledge that is applied to the corpus of law that is established by the Quran and the Sunnah. So that gives us the body of law. So we understand what world we're working off of. A lot of these Sharia principles, a lot of them may be ambiguous. There's a lot of room for interpretation. Obviously, with having the core document and having evolutionary decisions that build on that, provide for a lot of guidance, but there's still a lot of ambiguity. So we're going to go to before we go to that, if there's a question on a specific transaction or a specific structure, there are a number of organizations that exist. One is the Accounting and Auditing Organization for Islamic Financial Institutions. There are also other organizations, mostly sponsored by banks internally, that maintain Muslim scholars internally to ensure that their transactions are Sharia compliant. So it's possible to make sure that your client has discussed some of the issues with the bank. There's also the Fiqh Academy of the Organization of the Islamic Conference. There's a Sharia Supervisory Board that's within the Islamic Development Bank, which is a significant bank. And then Islamic Financial Services Board, that's based out of Kuala Lumpur. So there are a few boards that monitor these financial transactions for the banks. As you can see, there's a wealth of capital in these banks that a lot of the US investors are trying to access, and that they want to afford to Muslim investors and overseas investors to be able to bring that cash here. And so that's why it's important, it's critical for us to understand these. I will diverge for just a moment to say, this has been around. US Sharia law transactions in the US have been around for 40 years, since before the LLC became mainstream. So it's been around for a long time, and yet we are still just beginning to grasp how to address the tax issues and the finance strictures within the law. So again, that's why it's important to understand some of these things. Okay, let's go to the next slide. All right, the bottom line for the law, like most things, is that everything's permitted unless it's not. So those two words, what's permissible is halal, and if it's not permitted, it's haram. And that word haram, that's important to understand, because that affects certain transactions and what industries you might be able to participate in. All right, so there are 4 principles that are absolutely prohibited, that must be avoided, and then there are a couple more that give you a little bit more guidance. So the first one is riba. It's translated as excess, as in US terms, it's understood to be interest. So we deal with riba a lot, where we are trying to avoid the imposition of interest on loans. So the idea there, the concept is that riba leads to greed. It leads to usury. It leads to selfishness and principles that destroy the community. So the understanding behind Sharia law is that it's meant to build up. It's meant to incentivize charity, to help others, to distribute wealth. So when we look at each of these principles, we've got to understand that that's in the back of our mind, right? So the point behind riba is to make sure that you're not getting money for nothing, right? And interest is considered to be getting money for nothing. Now, it's important to understand, and that's also why in the exchange rate it's dollar for dollar. It's 1-to-1. If you're trading, I think the verse says, if you're trading barley, then trade equal barley for equal barley, or equal salt for equal salt. So it's got to be equal. By trading money in and of itself, money is not considered to be a valuable commodity. So money is money, and you can't make money off of it, because that's getting something for nothing. That's the concept there for riba. Now, what I was going to mention, it's very important to understand that interest-free banking does not equal profit-free banking. So there's a difference between interest and profit, and that's very important to understand as we go through it, because there are opportunities for profit, and profit is made, obviously, with the level of capital that's out there. There's plenty of profit, but it is in other forms, just not interest. So that's riba. We have gharar, which is undue uncertainty. So the purpose there is risk sharing. As we understand in the US, the banks are inclined to make a transaction as risk-free as possible. again, and we can see between the normal middle class and some of the more struggling lower class relationships with banks, that risk-free concept, stacking the deck in favor of the bank, creates animosity between the community. So in order to avoid that, if a loan is extended, there must be an element where the bank also assumes a portion of the risk. So there is that portion of it as well. Also not permitted is Messier, which, as you can see, it's related to undue uncertainty, but impermissible speculation. This is where your it's doesn't quite rise to the level of gambling, but might be something more akin to the stock exchange, where there's speculation, might go up, might go down, and you're making money off of that speculation, right? So that's also prohibited. Now, a little more extreme is Kimar. And, oh, sorry, going back to Garar, going back to Messier. Now, just because there can't be impermissible speculation, a business deal has a fair amount of speculation. A business deal has some risk. Those are permitted. In fact, as we'll see, some of these structures permit banks, these banks and individuals or investors, entrepreneurs, they go into partnerships together and they share that risk, or that risk is allocated entirely to one side. But it is a business risk. It is different from this impermissible level of speculation. And then Kimar, which is tantamount to gambling, entirely risky, entirely taking a chance. All right, so there's that. Now, couple more principles that help to guide us is that anything where that cash is going, so if this loan is going to be used for a business enterprise, it cannot go to anything that is haram. So that stretches into all other areas of life. So anything that is prohibited by the Muslim faith, you can't use that cash to invest in that prohibited activity. You don't have Sharia compliant loans going into casinos, the construction of a casino, for example. So there are those. And then, of course, unjust enrichment. That is sort of complementary to some of those other principles, particularly riba, but it is, again, off of that concept of getting something for nothing, being able to charge without really providing to the community. All right, so we have that. Now, I mentioned why that this has been in the US for at least 40 years, perhaps longer. And why are we so far behind? What is the issue? And a lot of that goes back to the First Amendment. And we look at that First Amendment where the IRS specifically can't tackle Sharia compliant financing because it is religious law, and they can't, for example, Congress can't pass a law that says that payments that would otherwise be considered interest are interest, right? So now, however, the IRS can go in and has audited transactions and reclassified certain transactions, certain payments as interest or as rental income, depending on the situation. And what you'll notice is this is very case specific in how the income is classified. It's really going to depend on what the documents say, what the parties intended, and the practices of the parties as to whether what is reported on the return is what it is, or whether it's reclassified. So that will be important to understand. But as a matter of statute, there's nothing in the U.S. code that specifically calls out Sharia compliant financing. So we're stuck with maneuvering around what we have. Okay, so let's go to the next slide, please. All right, so some individual considerations. These are just a couple items at the individual level to think about as you work with folks at the more at the 1040 level. The first one is zakat. Zakat is one of the 5 pillars of Islam, and zakat is charitable donations. They are mandated charitable donations, and it is 2.5% of one's wealth annually over a minimum calculated level of wealth. So there's a minimum number that they have to hit, and that's called nisab. And anything over that amount, and you're going to have to talk to your client about what that level is. Different countries have different calculations, and recall some countries have it codified, where zakat is mandatory. I'll come to that in a moment. But you check with your client as to what nisab is, and then over that they pay 2.5% in zakat for charitable purposes. Now, this comes in on the tax side, where if you have a client, say they're a resident alien, but they're a citizen of a Muslim Sharia compliant country, and they have to pay that 2.5%, we want to make sure that they get the deduction on the U.S. side. So we've got to make sure that we harmonize, there's that word again, their charitable donation, and make sure that it satisfies the 2.5% requirement, where that goes, and that it would otherwise be considered as a U.S. U.S. qualified donation to a tax-exempt organization. So that's one part of it. Another part to consider: marriage. Sharia law permits up to 4 wives. As you can imagine, that creates some issues with the estate tax exemption. Only the wife who is considered legal in the U.S. under U.S. law, assuming she's a U.S. person also, will receive the spousal deduction and enjoy portability. If the spouse is not a U.S. person, or sorry, not a Muslim, then that's another set of rules that I'll come to in just a moment. But in order to best address that lifetime exemption amount issue, we have to utilize some of the standard estate planning techniques of irrevocable trusts, non-grantor trusts, because gifts to individuals during lifetime, inter vivos gifts, are completely permitted under Sharia law. It is the estate, the transfer of the estate, that is governed by a lot of these. So if you look at the next bullet point down under inheritance, no non-Muslims can take from the inheritance. So what that means, while in the U.S., while that might be permitted under U.S. law, if you have a dual citizen, or if you have a Muslim decedent who leaves, say, a U.S. husband, and she has a real estate in a Sharia compliant country, then that country will not transfer the real estate to that non-Muslim surviving spouse. So there is that. 1/3 of the inheritance is discretionary. So again, to the extent that any of those assets reside in a Sharia compliant country, that 1/3 discretionary has to go to a Muslim, and it's the way that it's split is 1/3 goes to the spouse, 1/3 goes to the children, divided, and 1/3 goes to is that discretionary element provided they are Muslim. So certainly U.S. clients will want U.S. Muslim clients would want their estate planning to be Sharia compliant, but to the extent that they have an estate tax issue or that they have assets in a Sharia compliant country, those are some of the issues that you're going to want to keep in mind. And you're going to want to utilize the estate tax planning tools that we have available in the U.S. for inter vivos gifts in order to prevent post-mortem issues. All right, let's go to the next slide. All right, so loans and structures. This is where we get we're going to shift a little bit into the business side and look at some of the business issues. So I mentioned riba. We've talked about interest issues, and that's obviously where IRC 7872 looms large, where the IRS has the ability to impute interest to certain loans and collect the income tax that's due from that imputation. So first, I would note there are certain retail banks you're going to want to check if you've got a Muslim client who's receiving a mortgage, or you have investors who are looking for Sharia compliant financing. There are a number of banks that you want to look at. There are a handful of US banks, US-based banks, that can handle Sharia compliant financing. My last check, there are some, there's Lariba which is in California. That's a large mortgage lender. You've got University Islamic Financial, which is in Ann Arbor. You've got Devon Bank in Chicago, and then there are some of the larger banks are also establishing Sharia compliant divisions. So check with your bank first to make sure. So going back to the code and the IRS's ability. So in looking at the case law, first we have there are a couple of cases that I wanted to pull, and let's see. So I'm going to go backwards a bit. Commissioner v. First Security Bank. Under both of these, both Commissioner and First Security and Procter & Gamble, IRC 482, we're looking at IRC 482 and Procter & Gamble, where the commissioner wanted to impose or assess against Procter & Gamble the sorry, I lost my place here. The royalty income to the parent company. So from the Spanish subsidiary up to the parent company, and that so there was a question as to whether the IRS there we are, whether the IRS could do that. Sorry, this is in First Security. Yeah. Okay, so in First Security, they wanted to avoid the imposition of royalty income to the parent. The subsidiary had reported it in Spain. The IRS was trying to utilize 482 to bring it up. The Spanish law actually made it a crime to pass the royalties up and not report it. So both the tax court and the Court of Appeals held that it considered the Spanish law. It denied the IRS reallocation of the income, particularly, and it subjected, it limited the IRS's ability to reassess based on the laws of a foreign jurisdiction. So what we're looking at is the ability to pull in foreign law into the US tax code. And under a couple of subsequent cases in the 90s, the court said that foreign law is a means of implementing US law, not as a means of usurping it. So there are some cases where you can utilize that Sharia law, particularly if it's codified in a foreign jurisdiction, to support the argument for the position that's taken on the tax return. Now, before you think I'm getting too crazy, 7872, noting that 482 is very discretionary for the IRS. 7872 is a little stricter in imposing the interest income. So it's not necessarily that you can stand on these cases and say that the position you take is that you're able to completely pull in the Sharia law. It is simply one more aspect that cuts in your favor when you're preparing the tax return. So just keep that in mind. A lot of that is because, again, the case law that we have, specifically with respect to Sharia law and utilizing it in the US system, is very limited. So we're left with trying to simply build our arguments as we go, and it's very much a case-by-case analysis. So going one more to Procter & Gamble, the court refused to uphold the IRS's application of Section 482 when it was allocating royalty income. Oh, I apologize. That was the one that I just discussed. So under both of those, we have both the tax court, we have the U.S. courts that are relying on foreign law to limit the IRS's authority. Okay, so let's go to the next slide, please. All right. Under some of these loans and structures, I'm going to skip through a little bit here. Okay, so under these loans and structures, we've got Ijara, we have Istinsna, which is, we're going to skip over that one a little bit. We have Musharaka, we have Mudarba, and Muraba, and Sukuka. Okay, so Ijara is commonly, it's a lease sort of situation where the bank will go in, it will purchase the asset, and then it leases it to, it grants usage of the asset to the lessor, and then they pay the bank for consideration. And that rental payment is over time. Now, that can take place in a couple of contexts. It can be combined with this Istinsna, which is for a capital asset. It is for the development or construction of a capital asset where the bank will purchase the asset, and then it leases that asset to the client once that construction is completed. Now, the rental payments, as you can imagine, are factored in the purchase price, the time, the cost of construction, and remember, cost plus is permitted. So and again, these are that plus component is determined by these boards that advise the Sharia compliant banks as to what how much they can add on to prevent what, to prevent riba, to prevent unjust enrichment, and make sure that they stay fair. So under Istinsna, that's the capital asset. Musharaka, under that sharing, that is a partnership relationship where both partners can contribute capital. So under Musharaka, it's more of a partnership that's formed where the buyer, the borrower, the bank's client can come in with, say, a 20% down payment or a 10% down, whatever it is that they're required to put in. They contribute that to the partnership, and the bank contributes the rest of the cash to the partnership. As you can see, by establishing that partnership under a Musharaka structure, they are sharing risk. They're both participating in the risk that that business may or may not succeed. So under that, that's where, say again, for residential purchasing purposes, they have this partnership, and then the customer enters into an ijara relationship with the bank where they are paying the rent over time. And that partnership interest that the bank has can be chopped up into units, and the bank is selling those units back to the borrower over time. So you have some of the combination of some of these items here. Now under Mudarba, that is more of that's a little stricter, and that is more under the commercial context, where it's an investment fund. It's a real estate investment or real estate development, where there's a financing partner. They provide 100% of the financing. As you can imagine, that would be the bank. And then the operating partner, the mudarib, which there are different kinds of partners that they can be. The US analogy would be a limited partnership where you have limited partners and you have the general partner, right? Except it's a little bit different in that under Mudarba, the financing partner bears, well, depending on the role of the operating partner, typically the financing partner bears 100% of the risk of loss because they've provided 100% of the financing. So under that, you have to, you'll see that more commonly in the real estate areas. One other item, apologize, just a moment. Oh yes, under Mudarba also, one thing you'll find is that where you have a financing bank, where they provide the funds, they like the partnership structure because part of the requirement is that the US partner, the US Muslim partner, bears 100% of the responsibility for filing the tax returns and paying any tax that may be due. So for example, if you have an Musharaka situation within Ijra, where there's rental income that is attributable to the bank, rather than so that partner, that bank, in order to avoid filing a US tax return, they require the partner to be the tax matters partner in the US, and to bear the responsibility as part of their partnership obligations to pay the tax equivalent of whatever that would be, whatever the bank's tax liability would be. So what I've seen often is that that amount, whatever that annual amount is that is calculated into the amount of the loan, whatever that loan amount is, so that then the borrower is able to pay that tax liability. It's essentially a grossed up loan amount, which requires a lot of calculation, and again, you're going to have to get into the details of the transaction as to how much that would be, and when those tranches are distributed to the borrower, and so on. So there are a lot of moving parts there. Now, I see we have 15 minutes left. I'm going to go through a couple more of these. Murabaha that's an asset purchase transaction. That falls more into the commodities area, where you're purchasing rice, corn, inventory even. But under Murabaha, that is where the bank purchases the item, because one of the requirements is, again, impermissible speculation. You can't have it. So in order to sell an item, the seller must have possession of the item. It must be immediate and identifiable. Or sorry, the words are instant and absolute. They must have instant and absolute ownership of the item in order to be able to sell it. So again, avoiding the speculation, the bank's customer cannot purchase the commodity until the bank has it in their possession. So the bank has to purchase the commodity and immediately turn around and sell it to the seller. Now, a couple, as you can imagine, there are a couple of requirements there where again, profit is permitted, and profit can be added as a cost. And so that's typically what's done. It's a cost of the transaction, and so the requirements on a commodities transaction like that is it's got to be in possession, it's got to be instant and absolute, it's got to have value. The property has to be specific and identifiable. You can't have a situation where the bank buys it back immediately, because again, you're rolling the price. There has to be a certain specific price. So what you'll find is that forward contracts typically aren't a thing, don't exist under Sharia law. So and then the goods have to be tangible, and it has to be unconditional. Now, the ability for the customer to purchase that commodity from the bank has the ability to set the timing and terms of that repayment. Now, again, that sale has to be specific. There have to be dates on which payments are due, and they have to be specific. Now, one of the issues, though, or one of the issues is that those kinds of purchases, you cannot roll that transaction into another transaction. It's a sale contract, and once that transaction is done, it's closed. However, the exception is that there is an ability to reschedule repayment by the borrower. Now, this is important, because if a borrower or if a customer borrows funds without ever intending to repay, they are a thief. So and that's the black letter law. Now, if funds are borrowed, the time can be extended, it can be reassessed, but the bank cannot add additional charges for that rescheduling. Also, if there is a default, if the customer defaults, or if there's a late payment, any charges associated with that have to go to zakat. They go to a charity. So when you're looking at commodities purchasing, there are rescheduling permissions, but there are very specific requirements to the sale contract. All right, and then sukuk. This is the last financing structure that we have here. Those are often referred to as bonds, but they're more like trust certificates. So they identify beneficial and undivided beneficial ownership interest in an underlying asset. So you have the public who come together and they purchase, they contribute money to this trust fund. In exchange for contributing to the trust fund, they receive a certificate that represents their ownership in that asset. Let's say it's building a bridge. They have a beneficial ownership interest in that bridge. Now, let's say it's a toll bridge. If there's any income that is derived from that asset, as long as the certificate holders hold their certificates, the income is considered to be the property of the certificate holders, not the bond fund, not the sukuk fund. So that's a common theme throughout the pooling of money in Islamic finance. You have insurance, which I see we're short on time, so I'm going to jump to insurance a bit. Let's go to slide 11, please. So under that, you have a group of folks who want to help each other. And so they all put cash into essentially a trust fund. And that is called tabaru, where they give essentially a gift to a common fund that is intended to assist an individual. That is certainly permitted. So, and that is all in the interest of what is called ta'awun, which is mutual assistance. So you have them making a gift to this pot for mutual assistance. And from there, let's say that pot, those funds are taken and they are invested, they're utilized for profit-making purposes. It is important to note that the proceeds from that from those investments do not belong to the fund manager. They are considered to be the property of those who participate in the fund in proportion to their contribution. So that happens with often with homeowners. It happens with under business arrangements. You'll see that AIG has the ability to issue homeowners insurance. You have Zion Finance, which is in New York. They handle the takaful and retakaful. Now, the expenses associated with insurance, the income associated with insurance, you have to ensure that there is a secular purpose. Even though it's religious compliant, it has to have a secular purpose. And it can't foster excessive government involvement. So I'm going to, let's go down to, I apologize, we're going to go down a little bit. Let's go to the next slide. So a lot of the properties that utilize the murabaha structure, again, murabaha combined with ijara, that's where you have the partnership, and then you're leasing that partnership and purchasing the partnership interest from the bank. That happens a lot, as I mentioned, with hotels, dormitories, hospitals. Now, a lot of the time, we see that the Islamic compliant, the Sharia compliant bank serves a mezzanine role. So you have a conventional lender, and then the Islamic lender in the middle to provide that bridge between the Muslim client and the conventional bank to allow for that more traditional interest reporting structure that we're used to. In that case, it's important to have consistent agreements between between the mezzanine bank and the conventional lender to ensure how they're allocating that income, how they're classifying the interest income to ensure that it's Sharia compliant. So let's go to the next slide. All right. We have the investment funds, I think. Okay. We have investment funds. These are capital stack structures. This is where you're combining everything that I just described. You have certain variations on the partnership structures where you're allowing for more of that Muslim-based capital to come together, to be pulled together. You might have certain mudarbas coming together. And in all of that, you need to have the intercreditor agreements, and which I just mentioned, and make sure that those are compliant. Now, one thing that I do want to interject here, particularly at the on the cross-border level, and when we're dealing with real estate, we have in real estate finance, because you have these transfers between entities, you have perhaps it's not a formal formation of a partnership. There may be a joint venture, or there are transfers if that bank is serving as a mezzanine lender. You've got property tax issues that are imposed. And with that, or where you have a renter who's purchasing the portions of the property, let's say it's not a part, they're not purchasing the partnership interest, but actual portions of the real estate, you're having to record deed after deed after deed. Obviously, the real property transfer tax can get to be pretty prohibitive there. For one, the state of New York has abolished fees for those transactions that are executed under Ijra and Mudarba structures. A lot of places do still charge, so it'll be important to check with your local jurisdiction to determine how they handle Sharia compliant financing. All right, finally, I'm going to hit on the Waqf, which is similar to a trust, except there are a couple of differences. So the Waqif, the donor, transfers assets to the Waqf, which is an irrevocable trust. The Mutawali administers the trust. It has to be for charitable purposes. There is no intent to reclaim an interest in the asset. Now, that's all well and good for U.S. non-grantor trust purposes. However, for a Waqf, that transfer is actually it's a transfer of ownership to Allah. So there is, while that is the religious connotation for U.S. purposes, the Waqf gets its own tax ID number, and it would be taxed as a non-grantor trust. Now, you, of course, want to check as to whether it's a U.S. non-grantor trust, a foreign non-grantor trust. If it's a foreign non-grantor Waqf, then, of course, there are throwback tax issues for any undistributed net income for the U.S. beneficiary when that income or when income is derived. So in those situations, the best course of action is to simply establish the a U.S. non-grantor trust and establish that as the Waqf for any U.S.-based purposes. A lot of the time, those Waqfs, those are the supporting endowments that support the mosques that are constructed around the country. So the funds are aggregated there and then used to administer the mosque for tax-exempt purposes. So it's important to recognize that. and just make sure that you're checking on your cross-border issues. Hopefully, I've given you enough. There is a question here that mentions that asks about how Sharia law deals with the inflation of currency. That is really, that's built into the profit component, number one. Number two, as I mentioned earlier, a lot of that is built into the exchange rate, accounting, it's translation. A lot of that is built into the exchange rate, being able to transfer inflating dollars for whatever the other currency is, and vice versa. But again, just because interest isn't charged doesn't mean that profit can't be charged. So hopefully that gives you a bit to think about. Hopefully it's identified some of the animals that you see, and some of the issues that we're wrestling with as we report Sharia compliant financing.
Jared, thank you so much for that really interesting program. Hopefully people have gotten some information and some understanding. And Jared, if people have questions, I'm guessing they can reach out to you.
Absolutely, yeah, please.
Okay, yeah, and Jared's contact information is contained in the materials. So before we sign off, I just want to mention that our program next month on September 6th will be on handling trusts and S corps with foreign beneficiaries and the issues involved in that. It'll be presented by Cynthia Brattain from Carlin Peebles. If you are interested in getting more involved in this section, please come to our meetings. We meet on the third Thursday of every month at 8:30 in the morning on Zoom. Thank you all for joining us, and wishing everybody a wonderful rest of your day. Bye.
Thank you.